everybody. I'm Astha, a mentor at CLATapult. Today, we're going to talk about a certain type of alternative dispute resolution, that is arbitration. Now, would you know that certain conglomerates in India like Reliance, Infosys, Adani, Tata, they are no longer only relying on traditional litigation, but also resolving multiple disputes that are arising in their business through a process known as arbitration. Now, what is arbitration? Arbitration is a method through which two parties come together and autonomously decide who is going to hear their dispute and what the arbitral award on it should be. Now, when an arbitral award is passed, it is binding as per the Arbitration and Conciliation Act of 1996 in India. Now, what exactly are the processes under arbitration? So essentially what happens is the two parties to the dispute have under their contract that the dispute has arisen out of already decided what the dispute resolution should be. They typically talk about arbitration to be the way to resolve the dispute, and under that they talk about how many arbitrators they would require to form the arbitration tribunal. Now it could be 1, it could be 3, it could be 5. So then it is about the two parties and who they would want to be presiding over their arbitration. Because it is autonomous, the other benefit to it is also confidentiality. Now, a lot of matters, for the example, the Sony Marvel matter of for how much money would they want to sub-license the use of Spider-Man in the movies was also an arbitration. They would not want to disclose the figures to the public because companies want a deal in secrecy sometimes. For these kind of disputes, the way to go is arbitration because it will happen within a four-walled room and nobody would have to know about the particulars of the dispute but the two parties that were disputing. Another advantage, in addition to the confidentiality, is also the speed with which a dispute can be resolved. If we look at the current facts, about 4.5 crore cases are pending in the Indian judiciary. So when you do apply for a dispute to be litigated, it can take extremely long. With an arbitration, however, it is a time-bound process. Within the Arbitration and Conciliation Act itself, there are specific figures of 180 days or 90 days provided for resolution of certain parts of the arbitration proceedings. Therefore, it is going to happen much quicker. And given that the way in which it is proceeded is in your hands, as the parties, you get to decide what the timeline should be. Therefore, it is a lot more steadfast than litigation is. Now, since we've also spoken about the fact that it is a speedier recovery of dispute, another thing is about the fact that you get to customize your arbitration proceeding according to your own volitions. Both parties in the contract have or will mention what exactly is the process that they want to follow. Therefore, an arbitration is a lot more customizable. For example, you can decide the venue of arbitration. You can also decide what procedural rules should be applicable. Venue of arbitration essentially means where will the entire dispute resolution take place. So where will the parties convene to resolve this dispute? That could be any place. Your venue of arbitration could be within India or beyond India. Then there's something known as the seat of arbitration as well. And then the procedural rules. Procedure could be anything. There are multiple arbitral procedures available to choose from in the world. So you could choose from maybe, let's say, Singapore international arbitration rules. You could choose the Swiss arbitration rules. You could choose more at home. There are procedures provided under the Arbitration and Conciliation Act. So all of this will come in handy. The UNCITRAL model law, that obviously is the parent to many other rules that have been formed after. So all these rules are applicable and all these rules you can choose from. So it gives you the maximum customization possible to resolve your dispute. Now let's talk about neutrality. When we choose the arbitrators that are supposed to form the part of the arbitration tribunal, we also ensure then that all these arbitrators are neutral to the dispute. If they are not, then your award that is passed will no longer be enforceable because it is not fair. Therefore, neutrality is another significant component of arbitration. What else is important? The fact that the arbitral award be enforceable. So in terms of enforceability, the New York Convention provides enforceability in over 160 countries. Even in India, the second part of our Arbitration and Conciliation Act is about enforceability of domestic and international arbitral awards in India. Therefore, that also plays a significant role in ensuring that your disputes award is enforceable. Now, another thing that arbitration can aid with is the fact that arbitrators can be chosen as per their expertise. Now, what does that mean? Let's say if we take the Sony Marvel dispute, their dispute was over intellectual property. So, if you want to have arbitrators that have a fair idea of intellectual property, especially in the entertainment sector, which would only help us with understanding what is the value of a character like Spider-Man, then for that, your expertise as an arbitrator would really come in handy. So, expertise of arbitrator is something that you can also choose when you are arbitrating. Why? Because you yourself get to choose who your arbitrators are going to be. With that, we come to a conclusion of what arbitration is as a process and why it is something that a lot of companies and a lot of people in general are gearing towards. Thank you.